Hi, my name is Alisha and I'm going to be talking about the constitutional challenge to the Indian Child Welfare Act, or ICWA, for my honors project for English 103. So the Indian Child Welfare Act, or ICWA, was enacted in 1978 by Congress in order to address the separation of Indian or Native American children from their families. Congress was finding that non-tribal public and private agencies were taking a high percentage, around 85%, of Native American children from their homes and then placing them into adoptive homes or institutions that weren't related to tribes. Congress recognized that the fierce family ties and social and cultural values present in Native American communities were being threatened, and so then they enacted the ICWA in 1978. It establishes minimum federal standards for the removal of Native American children from their families and their placement in adoptive homes or foster homes. Congress's purpose was to protect the best interest of the Indian children and promote the security of Indian tribes by placing the children with extended family members in their tribe. First, it gives preference to a home with an extended family member, then to other members of the same tribe, then to the family of a different tribe. However, the U.S. Department of the Interior Indian Affairs has found that the protections, implementation, and interpretations vary greatly across different states. As of November of 2022, there are 7 plaintiffs that are challenging the constitutionality of ICWA. The plaintiffs are from the state of Texas and involve several families, 3 of which are non-native couples. They're white couples. The ICWA has been brought before the Supreme Court before, but never has its constitutionality been questioned, as was the case with Roe v. Wade. The case in question is Halan v. Brackeen. Among the arguments is whether the Equal Protection Clause is being violated by treating Native Americans differently, how much power Congress has to regulate Native American affairs. Justice Neil Gorsuch is one of the strongest champions of Native American sovereignty. He is arguing the Supreme Court has never struck down laws on the basis of Congress's authority to regulate Native American affairs. He also argues that it is not a state matter, but rather a federal matter. He says that it does not make sense for Congress to have a special interest in applying its laws on the state level when it hasn't been involved in Native American issues for decades, and additionally, the federal government has long been involved in family law. The white couple, Danielle and Jason Clifford, seek to adopt Native children and claim they are being discriminated against because of their race. They fostered a girl, Robin Bradshaw, named P.S., for 2 years and then tried to adopt her, but her grandmother refused to give her up for adoption. Her grandmother is from the White Earth Band of the Minnesota Chippewa tribe, and the judge says that Bradshaw's grandmother can nurture her connection to the tribe, to her Ojibwe culture, to her sister, and to both sides of her family. After 4 years in foster care, P.S. is back with the White Earth community, and her grandmother is learning how to swim, about regalia, and about the Ojibwe language. Jennifer and Chad Brackeen are another couple who are among the adoptive parents who are trying to adopt a child of a Navajo mother and a Cherokee father. The Native mother's rights were terminated by the state, then the Brackeens adopted the boy with the consent of the tribe. They are also pushing to get a girl adopted who was birthed from the same mother and entered the foster care system, but the tribe is objecting along with the child's great aunt. They wanted to be placed in the same home as her brother, and the issue of ICWA is that it is placing preference with extended family members, other tribal members, and other tribes before she can be placed in a home with her brother. Their lawyer, Matthew McGill, says that the real injustice of ICWA is that it deprives children of an individualized assessment of their own best interests, and it replaces the test with this hierarchy of preferences. He argues that ICWA classifies children based on whether they are Indian or not Indian, and then prospective parents based on whether they are Indian. Essentially, he is equating the ICWA's guidelines to an unconstitutional racial classification. Some are not seeing this issue. They are arguing that tribes are separate entities, so the provisions that the ICWA is drawing on have to be political rather than racial, and that this was made clear in Morton v. Mancari. In the end, Justice Neil Gorsuch, who was mentioned earlier, is concerned that if the Supreme Court strikes down ICWA on the basis of it exceeding congressional authority, then other laws that are intended to benefit Native Americans could also be struck down. Additionally, there are concerns that challenging adoptions related to Native children will translate into other cases affecting Native Americans, including environment, land, healthcare, religion, oil and mineral rights, and more. But even if all or some of ICWA protections are struck down, some states will still be providing protections in their state laws. 11 states have codified protections into state laws, including California, Iowa, Michigan, Minnesota, Nebraska, Oklahoma, Oregon, Wisconsin, and more states are still codifying protections. Marshall Gavin Jr. of the Little Chippewa tribe, he expresses the importance of ICWA in his life. He got placed into the child welfare system, and his first placement was with a white family. He's landed in different homes and schools with different cultures and languages, and it has caused him to have identity issues. He gravitated towards drugs, gangs, alcohol, and age 18 he became homeless and developed suicidal tendencies. His tribe wasn't federally recognized until 2019, so he wasn't protected under ICWA. For him, it has been a journey to unlearn, decolonize himself, and decolonize his mind. He wants to prevent people from having similar stories as his by educating social workers in the child welfare system. And so he recognizes the importance of ICWA in keeping him connected to his family, his roots, and his lineage. And he also recognized the importance of having fierce family ties, community, and being connected to his cultural roots. Munday Vanderwalker of the Rosebud Sioux tribe also expresses how ICWA saved her nephews. The DSS, Department of Social Services, wouldn't move forward with her case, and after waiting for a phone call for many years, she was able to go see them in their foster family home. The foster family tried blocking her and her husband's visits and tried to argue he wasn't a tribal member, so he didn't have ICWA protections, but he in fact was. After 3.5 years, the ICWA finally allowed Vanderwalker to adopt her nephews. She's taught them about powwows, Indian tacos, fry bread, and their ancestors. DSS wasn't doing enough to help Native Americans be placed with their families until ICWA guidelines were implemented. And then her nephews were returned to her family. The Supreme Court has been a major test for ICWA since the narrow ruling of 5-4 in the adoptive couple v. Baby Girl. Christy Maldonado was engaged to be married to Dustin Brown, and in 2009 she was pregnant with baby Veronica. The relationship went downhill, and she broke off the engagement for whatever reason. It led up to Dustin eventually giving up his parental rights and deciding not to support the child, leaving Christy struggling. She decided to put baby Veronica up for adoption, and she found Matt and Melanie Copabianco, who were willing to support Christy with her delivery. Christy sent a letter to Cherokee Nation of her adoption plans and gave them permission to intervene, but the tribe had no record of Dustin Brown, so the adoption went forward. But 4 months later, as Dustin was being deployed to Iraq, he signed off on the adoption papers. Days later, though, he invoked ICWA. He said he thought he was giving full custody to Christy when he was relinquishing his parental rights. When he heard of the adoption, he sought full custody of baby Veronica. The birth mother sided with the Copabiancos in court to represent the best interests of baby Veronica. Baby Veronica lived contentedly with her adoptive parents, and Christy could keep in contact with them and talk to her child regularly, but upon giving baby Veronica to Dustin, Christy is now unknown to how her child is living or even where she lives. Dustin claims he has been trying to keep baby Veronica from the legal issues and allowing her to become used to her new home with him. ICWA is meant to protect Native children from being snatched away from their families forcibly, but wasn't it in baby Veronica's best interest to be with the Copabiancas and her birth mother? The father renounced his parental rights, would not provide for her financially, and the mother struggled to care for her on her own. Suddenly he played the biological card, and because he is a citizen of the Cherokee Nation, he received full custody. That concludes my presentation. Thank you.